Now, it's my distinct pleasure to introduce Catherine Franke, the James L. Dorr Professor of Law and Director of the Center for Gender and Sexuality Law at Columbia. She is among the nation's leading scholars writing on law, sexuality, gender-based equality, and race. She's also the founder and faculty director of the ERA project here, where we develop academically rigorous research, policy papers, expert guidance, and strategic leadership on the Equal Rights Amendment to the US Constitution, and on the role of the ERA in advancing the larger cause of gender-based justice. And it's an honor and delight to get to work with her every single day. I'll also note that Professor Franke is widely published in both scholarly and popular venues. Her book, Repair, Redeeming the Promise of Abolition, makes a case for racial reparations in the US by returning to a time at the end of the Civil War, when many formerly enslaved people were provided land explicitly as a form of reparation. And her first book, Wedlocked, The Perils of Marriage Equality, considers the costs of winning marriage rights for same-sex couples today and for African Americans at the end of the Civil War. Welcome, Catherine.
Thank you, Ting Ting, and just congratulations to you and to Lilia Hadjivanova, who's our Assistant Director here at the Center for Gender and Sexuality Law, for a really successful first day of the symposium yesterday. I think that there's so many advocates, members of Congress, members of state legislatures, just members of the public, lawyers and others who were desperate to know about what will the ERA do? Why do we need it? What are the impediments to actually finalizing and ratifying the final ratification of the ERA in a deep way? And that's what we've been doing over these 2 days. Our panels yesterday were just out of sight, if I can say. We really dug deep in a range of issues that really lie at the core of vexing problems of sex equality that are enduring and that may be and should be addressed by an ERA. We pick up that conversation this morning with thinking specifically about reproductive justice, reproductive rights, and abortion specifically. We so often at the ERA project get questions from members of Congress, from the public, from the media about, well, would the ERA require access to abortion? Why would it? And in what way would it? And why doesn't current existing equal protection, equality protections that are in the Constitution also mandate access to abortion? So this panel, among the most leading scholars in the country, all three of whom I just hold with such esteem, who I've learned from, who continue to teach me about the histories and meanings of constitutional equality in a range of ways, will cast some light on those hard questions about the current law, constitutional law, as it relates to access to abortion, and then what an ERA might do in solidifying, if not advancing, those rights. Our first speaker is going to be Reva Siegel, who is the Nicholas D.B. Katzenbach Professor of Law at Yale Law School. She is an incredibly prolific scholar whose work has, in fundamental and multiple ways, shaped the fields of sex equality, reproductive rights, popular constitutionalism, and constitutional law more generally. She, along with Professors Serena Mayeri and Melissa Murray, co-authored an amicus brief in the Dobbs case, that case that's from Mississippi that's pending before the Supreme Court right now, in which they clearly articulated a path for the court to reaffirm a right to abortion as a matter of sex-based equality. Serena Mayeri will be speaking second and is a professor of law and history at the University of Pennsylvania Carey School of Law. Her work focuses on the historical impact of progressive and conservative social movements on legal and constitutional change. Her prize-winning book, Reasoning from Race, Feminism, Law, and the Civil Rights Revolution from Harvard University Press in 2011, offers original and groundbreaking insights into how the civil rights movement and women's movements work together and how the analogy of sex to race discrimination shaped political activism in the streets, in the courts, and in the Supreme Court in thinking about the jurisprudence of equality. Carrie Franklin will come next, who is the McDonald Wright Chair of Law and Faculty Director of the Williams Institute, new Faculty Director of the Williams Institute at UCLA School of Law. We're so thrilled that Carrie made a move from Texas to LA to head up the Williams Institute. Her work focuses on the historical development of conceptions of equality in American law and how this history influences the shape of contemporary legal protections in the context of sex, sexual orientation, gender identity, and race. Her work has given us new and deeper ways to understand the law and histories of sex, sexual orientation, reproductive, and racial justice. Welcome to all three of you. It's wonderful to have you here to have this conversation about the ERA, about the current Constitution, and abortion rights. So I'm going to invite Reva Siegel to get us started in talking about the relationship of the current language of the Equal Protection Clause to abortion rights and some of what they tried to do in the Dobbs brief. Reva, please take it away.
Okay, thanks so much to Catherine and to Ting Ting for convening us, and to the Journal of Gender and Law, and to all the panelists who spoke so compellingly yesterday. And though she's not here, I also wanted to express special appreciation to Senator Jen McClellan, who I thought gave a really energizing, open, ever since Julie Sook took me on a road trip to Virginia, and I think it was October of 2019, I've been something of a fangirl of hers. So to begin, Melissa Murray, Serena, and I filed an equal protection brief in Dobbs challenging Mississippi's ban on abortion after 15 weeks. And Serena and I are going to be discussing that brief this morning. In order to save time to discuss the argument of the brief, I'm going to introduce the brief by locating its equal protection claims to abortion bans in a bit of history and relating equal protection arguments to the ERA in just the most skeletal kind of way, just to save time. I'm sure we'll wind up going back to discussing this a bit in Q&A. Both Serena and I have written about it in the past. So in the late 1970s, for reasons that are too complicated now to unpack, Phyllis Schlafly began to focus her attack on the Equal Rights Amendment on the claim that the ERA would constitutionalize abortion rights and same-sex marriage. I think it was like about 77 that she began to really drill down on this claim. Most on the left, appreciating the political danger, dodged the equality question by insisting that they supported abortion and gay rights, but that the court would support abortion and gay rights as liberty rights under the Due Process Clause. The attack produced a politically upside-down world in which, for generations, opponents of the ERA insisted that the ERA would constitutionalize protections for abortion, the abortion right, while supporters of the ERA either denied or stuttered about these matters. Today, there's no more solid source for the claim that the ERA supports abortion rights than Phyllis Schlafly herself. This state of affairs persisted for more than 40 years, with certain glorious exceptions, like Senator McClellan, as you heard yesterday, opening the conference. So today, Serena and I hope to put an end to key discursive premises of this argument. So observe that the first premise of the abortion objection to the ERA is that abortion rights are liberty rights depending on the Due Process Clause, and further that the Equal Protection Clause is silent on the subject of abortion. ERA threatens the pro-life movement because only by ratifying the ERA would the Constitution impose equality constraints on the regulation of abortion. So we're here to dispute that initial premise to show that the Equal Protection Clause of the 14th Amendment, interpreted under canonical cases decided since the 1990s, limits the regulation of abortion, or would if the Equal Protection Clause were enforced by a court that had not been packed with pro-life justices. We can also discuss that in Q&A. In what follows, Serena and I will split presentation of the equal protection brief that we filed challenging the 15-week ban in Dobbs. We built our brief on a little appreciated feature of Justice Ginsburg's landmark opinion in Virginia. Virginia reasons about laws regulating pregnancy as a form of sex-based state action. No one has paid attention to the language in Virginia that we will discuss, I believe, because most assume that the court's 1974 decision in Griswold versus Aiello is still good law, as they say. So Griswold held that laws regulating pregnancy were not sex classifications that triggered heightened equal protection scrutiny as other sex-based classifications do. The court reasoned from the premise that sexual stereotyping stopped where so-called real physical differences began. a practice of reasoning from the body that I long ago called physiological naturalism. When the court started to extend its reading of Geduldig into federal employment discrimination law in the 1970s, the women's movement organized and said no, helping to enact the Pregnancy Discrimination Amendment to Title VII, which recognized that employment practices that discriminate against pregnant persons discriminate on the basis of sex. So if you've all heard of the PDA, Pregnancy Discrimination Amendment to Title VII, federal employment discrimination law, that's its genesis. The effort to prevent the extension of this Geduldig case into federal employment discrimination law. As courts acquired decades of experience interpreting the PDA, liberal and conservative justices have come to recognize that pregnant employees are subject to sexual stereotyping. 25 years after passage of the PDA, the court held in Department of Human Resources versus Hibbs that Congress can enforce the Equal Protection Clause by enacting the family and leave provisions of the FMLA in order to redress sexual stereotyping of pregnant workers. Without so much as citing Geduldig, which the court's not cited in a single equal protection decision since the mid-70s, Chief Justice Rehnquist reasoned for the majority in Hibbs in 2003 that many states' sex-based family leave policies, that is to say, extending maternity leave to women but not to men, were, quote, not attributable to any differential physical needs of men and women, but rather to the pervasive sexual stereotype that caring for family members is women's work, close quote. In Hibbs, Chief Justice Rehnquist asserted that the Equal Protection Clause prohibits sex stereotyping of pregnant workers, or what the decision in Congress referred to as discrimination against women when they are mothers or mothers-to-be, close quote. A growing number of commentators recognize that Hibbs has superseded Geduldig, but they've not looked back to see that it was in fact Justice Ginsburg's opinion in Virginia that opened the door. The reading of Virginia that follows is the basis of the equal protection brief that Serena, Melissa, and I filed in Dobbs. Our brief builds on a little appreciated feature of Justice Ginsburg's landmark opinion in Virginia. Virginia reasons about laws regulating pregnancy as a form of sex-based state action subject to the ordinary intermediate scrutiny framework. It's not an accidental feature of the opinion. Justice Ginsburg's opinion works to focus equality analysis not on grounds of sameness, but on grounds of social status. Differences, the court explained, quote, remain cause for celebration, but not for denigration of members of either sex or for artificial constraints on an individual's opportunity, close quote. To illustrate a sex classification, the Virginia majority pointed to a state law about pregnancy, about maternity leave, again, upheld under the Pregnancy Discrimination Act in California Federal Savings and Loan Association versus Guerra, as an illustration of a sex-based law that is constitutional in the court's analysis in Virginia because the law promoted rather than restricted equal opportunity. Virginia explains that government may employ sex classifications, citing CalFed, if providing employment opportunity or remedying past discrimination, but then warns that, quote, classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women, close quote, providing a framework within which all forms of sex classification, including those involving pregnancy, can be evaluated. Virginia's test breaks with the physiological naturalism of cases like Geduldig and looks to social relationships rather than biology or the body to determine whether state action classifying on the basis of sex, including pregnancy, violates equal protection. Where Professor Kendall Thomas read Virginia as reifying biological difference, our brief reads Virginia as repudiating reasoning from the body in the earlier case law, as I believe actually that Kerry Franklin's Supreme Court review article does as well. Virginia provides an equal protection framework for evaluating the 15-week ban at issue in Dobbs. And under the familiar intermediate standard recited in Virginia, Mississippi has to show its decision to regulate by sex discriminatory means is substantially related to the achievement of an important governmental end, the most familiar form of intermediate scrutiny test. This means end showing certainly seems like an easy standard to meet in justifying an abortion ban. In fact, it's usually seen to be fatal in the abortion context. But Virginia requires a government to offer a, quote, exceedingly persuasive justification, close quote, for its use of any sex-based classification. That is, Virginia requires the government to justify its use of sex-based and coercive means without relying on, quote, overbroad generalizations about the different talents, capacities, or preferences of males and females. Mississippi's abortion ban fails that test. I'm going to just enumerate a couple reasons why. One, sex-based classification. Mississippi's abortion ban is expressly sex-based. The statute prohibits physicians from performing an abortion on, quote, what the statute terms a maternal patient, close quote, after 15 weeks. That's the statute's own language. Two, sex role-based coercion. The state singles out a pregnant woman and compels her to continue the pregnancy, expressly imposing on her what the statute expressly terms a, quote, maternal role. Three, gender paternalist justification. Now I'm getting deeper into what will be part 2 of our brief. Consider the way the law justifies the use of coercion. The preamble of the statute advances 2 protective justifications for the 15-week abortion ban. Mississippi claims the 15-week ban was enacted, 1, quote unquote, to protect the life of the unborn. This is the preamble of the Mississippi statute at issue in Dobbs. And 2, quote unquote, to protect the health of women. Instead of acknowledging and endeavoring to offset any health or life burdens on women who are coerced into childbearing by the state, Mississippi instead claims that in coercing motherhood over a woman's objection, the state is, quote, this is not a quote, this is me explaining, is protecting the woman in addition to any fetal life she may carry. The history in part 2 of our brief makes legible the particular sex role stereotypes that makes coercion reasonable as a form of protection. In part 2 of the brief, we show that the state's gender paternalistic justification rests on distinctive stereotypes as a set of sex role-based claims about women as destined for motherhood that date back to the 19th century anti-abortion campaign. There's abundant evidence in part 2 of the brief, and continue to play an important role in the modern pro-life movement. Relying on these antiquated stereotypes, Mississippi assumed it could fulfill both of its important objectives, protecting fetal life and protecting women's health without conflict by prohibiting abortion in this way. Bingo, coercing women helps women and babies and shows Mississippians love both. 4, by expanding, and this is my last point, and I'm turning this over to Serena now, and this is a critical point in the brief. By expanding the policy frame and looking beyond the abortion context, we show that the state singled out and targeted women who resisted motherhood. Observe, under heightened scrutiny, the state must demonstrate that it was unable to achieve its goals by non-discriminatory means before it moved to sex-based coercive means. I'm going to stop and repeat that again. Under heightened scrutiny in the anti-discrimination tradition, in order to use a sex-based classification, the state had to demonstrate the need for it. It had to show why it didn't proceed by facially neutral inclusive means, but actually needed to rely on sex-based means. By expanding the frame and looking beyond the abortion context, we can ask, why or what else could Mississippi have done without relying on the specific abortion ban that it chose? To protect life and health, did Mississippi have to rely on sex-based coercive means at all? In part 3 of our brief, as Serena is about to discuss, we show that Mississippi failed to explore the many less discriminatory and non-coercive ways the state could have, 1, reduced abortion, and 2, protected the life and health of women and future generations, such as by providing appropriate and effective sex education and contraceptive access to those who wanted to avoid becoming parents and assisting all who wanted to bear and raise healthy families. And Serena, it's up to you.
Thank you so much. I want to echo Reva's thanks to Catherine Franke and Ting Ting Chang and the students at the Columbia Journal of Gender and the Law. It's really a pleasure and privilege to be here. So I was going to pick up where Riva left off and talk a little bit about the second half of our argument in the Dobbs brief. And as Riva said, this is where we argue that Mississippi's stated goals of protecting fetal life and women's health, of course, are laudable goals, but that in choosing abortion restriction as the primary means to that end, that Mississippi rejected many less discriminatory alternatives it could have used to achieve that end. So this is where we put into practice the expanded frame that Riva has been talking about. And as she said, we're asking essentially if Mississippi weren't blinded by these sex-based assumptions and stereotypes about women's natural role as mothers, what might they have done to protect women's health, to protect fetal health, to protect the health of living children and families? So I want to talk about a few of the examples that we used in the brief, and we sort of selected these from, unfortunately, many examples that we could have pointed to. We can talk more about what those are as well. So first, we talked about how Mississippi has the highest rates of infant mortality in the nation, as well as egregiously high rates of maternal mortality, especially for Black women, who are 3 times more likely than white women to die in childbirth. And the demographics of Mississippi here are not unusual in the degree to which women of color are and poor women are impacted, of course, by abortion restrictions, but they are particularly stark. And those maternal mortality statistics, are just about mortality. It doesn't even count, these statistics don't even count all the other devastating short and long-term impacts on health that pregnancy can have when pregnant people don't have access to adequate medical care. So we know that access to regular health care and checkups can reduce maternal deaths, it's estimated by up to 60%. So you might think that pro-life Mississippi lawmakers must have jumped at the chance to, for example, expand Medicaid. They didn't, even though it would have brought much needed federal dollars to the state. And there are a number of other examples of how Mississippi not only missed opportunities to protect the health of women and children, but rejected federal funding that would otherwise have been available had they chosen to take it. So lack of financial resources, right, is among the most common reasons that women cite for ending pregnancies. So of course you would expect, right, that Mississippi would spend all of its temporary assistance for needy families, TANF, public assistance funds to provide aid to families. In fact, however, Mississippi spent only about 5% of its TANF funds on direct assistance to families in 2019. And until last year, the state had the lowest TANF benefits in the nation and had reduced eligibility so much that only 3,000 families, down from 23,000 a decade earlier, less than 5% of the families who applied for TANF actually received it. Another point that we talked about was had to do with access to and education about contraception. So we know that accurate information about and access to contraception lowers rates of unplanned pregnancies, right? But Mississippi, when faced with the choice of providing accurate sex education and funding for contraceptives, instead chose abstinence-only education. And in fact, the state funded a teen pregnancy summit a few years ago, actively discouraging the use of contraceptives. And all of this we discussed results in one of the nation's highest rates, not surprisingly, of teen pregnancy, not to mention sexually transmitted infections like chlamydia and syphilis. So that's the third part of the brief, where we're talking about examples of less discriminatory alternatives that the state of Mississippi and the many other states who've restricted abortion could choose instead of restricting abortion to accomplish the ends of protecting women's and babies' health. Then in the final section of the brief, and this part was especially inspired by our co-author Melissa Murray's fantastic article, Racing Roe, we tried to refute what's become an increasingly popular notion on the right among supporters of abortion restrictions, that allowing women of color, especially Black women, to access abortion is a form of eugenics. So, so here, what we're trying to show is that, and maybe this might seem a little bit obvious, but we're trying to argue that state policies of reproductive control, such as the forced sterilization imposed on Black women, once so common in Mississippi that they were called Mississippi appendectomies, that those kinds of policies that are being compared to abortion are essentially the antithesis, right, of allowing individuals the right to make reproductive decisions free from state coercion. So in one case, you have state coercion. In the other case, you have freedom from state coercion. And second, and this also draws on Melissa Murray's work, we try to point out that the fact that poor women and women of color decide to end their pregnancies more often than do well-off white women is more a result of state policies like Mississippi's that make it very difficult for people who do carry pregnancies to term to provide their children with the support and care that they need. So the point that we close on is that these arguments that abortion is like eugenics effectively blame Black women for the effects of the state's inadequate social and economic supports. So I'm going to stop there and turn it over to Carrie.
Hi. First of all, I wanted to echo the thanks to Catherine and to all the organizers of this conference at the ERA Center in Columbia more generally who put this event together. I am so happy to be here on this panel with these three shining lights from whom I have learned so much about sex equality. So thank you all, and I'm really looking forward to our conversation. Serena talked a little bit about race and its centrality to the sex equality argument. I wanted to spend a few minutes talking about the highly overlapping and intertwined strand of the sex equality argument that involves class or financial disadvantage. And I'll start just by noting or echoing what has been noted, that Dobbs is a case out of Mississippi, and other recent cases at the Supreme Court involving the restriction of abortion rights involve Texas and Louisiana. These states aren't just bound by draconian abortion regulation. They are also states with some of the most meager forms of social provision to the poor. So you heard some of the statistics about health outcomes, maternal mortality rates, fetal mortality rates, healthcare coverage. Mississippi and Texas are among 12 states that still refuse to expand Medicaid. Nationwide, about 75% of women who receive abortions are poor or low income. In Mississippi, the home of Dobbs, the percentages are almost certainly worse. The vast majority of women in Mississippi seeking abortions are poor and also Black. Now, the brief my co-panelists wrote talks a bit about the ways in which Griswold, the case decided by the Supreme Court in the early 70s, has been overread to suggest that pregnancy classifications are never sex classifications. I want to talk for a bit about an article I wrote a few years ago, arguing that the abortion funding cases of the 1970s have sometimes been overread in similar ways to stand for the proposition that abortion law utterly disregards and is utterly insensitive to the needs of poor women. So this is a set of cases in the 1970s in which the Supreme Court held that the government is not obligated under the 14th Amendment to pay for abortion through Medicaid or through public hospitals. And that is indeed a blow to poor women. But those cases, if you look in the scholarship, those cases have sometimes been misinterpreted, overread to mean that abortion doctrine under the 14th Amendment is simply unconcerned about the needs of poor women. You're on your own. If you can't afford it, that's your lookout. It's not a matter of constitutional concern. I just want to say that that misses a lot of important history about the ways in which concerns about poor women and advocacy on behalf of and by poor women powerfully shaped the development of reproductive rights law in this country. And some of those concerns are inscribed in current doctrine. So I can't run through all of the history in my article, but I'll just say that if you look back to the original, one of the most important foundational reproductive rights cases, Griswold v. Connecticut, which strikes down a ban on contraception for married couples in Connecticut, you will see that driving that litigation is a concern that birth control clinics, which service poor women, are being shut down, and women can't afford to leave the state and don't have the same access that middle-class women do to birth control. And that was central in the briefs in Griswold, central also in the advocacy around abortion rights in this period. Now, if you've read the cases, you will know that these concerns about class, concerns about poor women, were not explicitly articulated in the reproductive rights doctrine the court created in the 60s, in the 70s, and even beyond. But I want to say that doesn't mean those concerns haven't shaped our law. So the first thing I want to say is the reason a number of rights were declared fundamental rights by the court to begin with in the 1960s and 70s is because they were intersectional. They concerned both fundamental rights and groups that were particularly vulnerable that were being completely excluded from those rights. So poll taxes, literacy tests for voting are struck down. Lawyers are required to be provided by the state to people who can't afford them. There are a number of criminal procedure rights, and I argue a number of reproductive rights that enter the pantheon of fundamental rights to begin with, in part out of a concern that poor women and poor people are being excluded from those rights entirely. And second, I'll just say, the final thing I'll say on this piece is that I think those concerns have been enfolded into abortion law over the years. So here's one, I'll just give two examples. Here's one. In Roe, in 1973, Justice Blackmun circulates his opinion when he lays out a trimester framework. And he originally says the point at which the state's interest is going to be compelling and the state can ban abortion is at the end of a woman's first trimester. Thurgood Marshall writes back and says, I have experience in Baltimore, in Harlem, seeing poor Black women die as a result of not being able to access abortion. One trimester is not long enough for poor people to be able to obtain these rights. And as a result of that conversation, the point at which the state's interest becomes compelling gets moved back to the end of the second trimester, directly in response to these concerns about poor women's inability to quickly access expensive care that may not be available in their neighborhood. And the other example that I'll talk about is in Casey, where the court articulated an undue burden test that says the state can't unduly burden the right to abortion. There has been skirmishing in recent years where more conservative courts, the Fifth Circuit and Justice Alito, have started to argue that you can't take into consideration in the undue burden calculus poverty and circumstances that are of a woman's own making or of her own, to do with her own life, not created by the state. So if she doesn't have a car, if she can't buy a bus ticket, if she doesn't have childcare or can't get time off from work or doesn't have money for hotels and travel, all of that doesn't go into the calculus of whether the state has created an undue burden because it is not responsible for creating those circumstances. We could have an argument about the state's culpability for those circumstances, but leaving that aside, the court has repeatedly rejected the attempt to say that those kinds of concerns are outside the sphere of the undue burden test, and Justice Breyer resoundingly looks to the real life experiences of Texas abortion cases and the whole women's health case from a couple of years ago and says we do consider all of that in judging whether an abortion restriction constitutes an undue burden. Okay, at this point, you may be asking, why does all of this matter going forward? There's a very real possibility this doctrine may all be soon wiped out. Roe's trimester framework is long gone. The undue burden test is quite likely to disappear or be reduced to some shred of its former not entirely robust self. So it's true that the arguments that I have been making today, and I think that are the subject of this panel, the sex equality arguments, are unlikely to move the majority in Dobbs. I think there's a strong possibility that the court will uphold the ban without even acknowledging the equality arguments. But I want to say, I don't think that diminishes the importance of these arguments. In fact, I think it underscores the importance of these arguments for a couple of reasons. One, Supreme Court is not the only court, and the Due Process Clause of the 14th Amendment is not the only source of legal protection for reproductive rights. And here's where we start to move into the subject of this conference. So, and I would love, I'm happy that I have the chance to nod to Catherine and to Ting Ting, who wrote an important brief in a case, a reproductive rights case under the Pennsylvania ERA, in which they trace some of the same kind of history that I've been talking about, talk about the way in which concerns about poor women influence the development of the ERA are important to take factors to take into consideration in interpreting the Pennsylvania ERA. There are many state ERAs, a national ERA, state equal protection provisions, other sources of law where one could tell similar histories to the one that I've been telling. And I think it's important to do so because these arguments give context. They kind of expand the frame in Riva's language and potentially connect current restrictions and regulations to histories that extend back to slavery, that extend back to the eugenics movement, that involve extreme forms of reproductive control and punishment directed at poor women, drug testing, removal of children, failure to treat poor and non-white women as full members of the community entitled to equal regard, but instead punishing them and restricting their rights. And these kinds of arguments can provide important context for current, when we're assessing the legality of current regulations of abortion under provisions all across the country, including ERA provisions. This is also relevant outside of courts because it provides a pretty good reproductive justice agenda for legislators who are interested in ensuring equality, especially along race and class lines in the repro area. I'll just say in my recently departed home state of Texas, Texas, as many of you know, passed a draconian abortion restriction a couple of years ago that ended up closing a lot of clinics. It was a set of trap laws that required clinics to meet all sort of impossible goals. And one thing that legislators did in Texas, legislators who opposed this law, is they introduced a series of amendments to the law to say, okay, we can institute these if we're instituting these clinic closing laws, and you're saying that we're doing so out of concern for women, let's also expand evidence-based sex ed. Let's adopt Medicaid. Let's expand TANF to pregnant women. Let's expand Medicaid. Let's prevent these clinic closing laws from taking into effect until the rate of Texans who are uninsured has fallen below 5%. I just want to say part of the goal, obviously, was to show to future courts that these laws weren't actually motivated by concern for women and families. But this series of amendments also provides a pretty good legislative agenda for people who are concerned about the histories that I've been talking about today. So in conclusion, I'll just say, it remains to be seen what's going to be left after Dobbs. But I think regardless of what the court said, it will not wipe out the history and the conceptual frames that I've been talking about here. Right? There are conceptual understandings of sex equality built around poor and non-white women that are and will remain entrenched in our law in various places, including under various ERAs. Right? And the work needs to be done to understand those claims and that history, and to put current regulations under those laws into context. My sense is that the arc of the moral universe will not bend toward justice this summer at 1 First Street, and potentially won't there for some time. But I think these equality projects will continue, and my hope is that they will assume a greater centrality going forward once the less than ideal framings that the court gave us in Roe no longer need to be defended.
Great, thank you so much, all three of you. Carrie, I didn't know if you wanted to pass it back to Serena, or if I can start asking you some follow-up questions related to the amazing set of issues that you all have put out on the table.
You know what, I think this is a big chunk, and it would be nice to have some conversation, and then we can shift.
Good. So let's for a little bit kind of do a more of a roundtable format here. You know, one of the things that we struggled with in our Pennsylvania brief, and Pennsylvania has ratified, has a state ERA, has the ERA language in its state constitution, and advocates in Philadelphia have challenged the state's ban on Medicaid funding for abortion under the state ERA, saying it amounts to sex discrimination. Sounds like Phyllis Schlafly, were she alive, would be writing a brief in support of that position, as Reva started us off with. But one of the things we struggled with in that brief, and I know you did too, in your Dobbs brief, is how to frame the sex equality argument in favor of access to abortion or against abortion bans in a way that doesn't reify a sexual binary. That is, that it's only women, biologically described or otherwise, who are the rights bearers of this sex equality right. And in that sense, we wanted our argument to, at a minimum, not be transphobic, and at a maximum to be trans inclusive. And it's a challenging thing to do. And I know you all struggled with that as well in your Dobbs brief. So I'd like to hear from any or all of you about how we do that, how we are thinking sex, sexual identity, and pregnancy in different ways today than we did in the 1970s and 80s. And in ways that understand that trans men can be pregnant too. So how do we unpack that? How do we make that argument? Reva, do you want to start us off?
Well, I might, although I think that Serena had actually, when we had divvied things up, Serena had prepared to weigh in on that point. So I don't want to, since she had organized, I think I'll follow after Serena.
Serena, please.
Sure, thank you. So this was something, as you said, that we also thought very deeply about. And, you know, I think it's a really important consideration in all sorts of areas, but it's particularly so in this one, in the sense that the challenge that we were facing specific to the arguments that we were trying to make were sort of several-fold, right? So one is that what we were trying to draw attention to, in large part, was the fact that the lawmakers who passed these abortion restrictions, they have in their minds a particular narrative about cisgender women, right? They are thinking in very binary terms about sex and gender. And in fact, it's exactly those lawmakers' sex and gender-based assumptions and stereotypes that we're trying to expose in making the argument that this is problematic from a constitutional sex equality perspective. So of course, to do that, because the mostly men enacting these restrictions thought in terms of women, we too needed to explain in terms of women what those stereotypes were about. And I think another set of challenges relates to the fact that the precedents that we're relying on don't explicitly contemplate anything beyond the binary. Now, I want to be clear, I think that they very much accommodate thinking about sex and gender in a much more expansive and inclusive way. But they don't, the precedents that we have don't speak in those terms. Even the more expansive, somewhat more expansive conception of sex articulated in Bostock is still pretty binary in nature, at least on its face. And I think we were also thinking about the fact that the audience that we're writing for is going to include readers who may already be having trouble understanding abortion as a question of equal protection doctrine to begin with, right? And may, perhaps not be especially well versed in feminist theory, much less queer theory, to kind of understand the more nuanced aspects of this. So I think it's fair to say it was really important to us to be as gender inclusive as possible and not to communicate any sense of an inherent tension between the goals of trans and queer inclusivity on the one hand and equal protection, sex equality arguments on the other. So I'll just say a little bit about what we did in the brief to try to square this circle or to reconcile these goals. So one thing that we did was very early in the brief, early in the summary of the argument, we wanted to have a really explicit acknowledgement of how abortion restrictions do implicate many kinds of sex and gender-based stereotypes. And to clarify that our brief was going to be focusing primarily on a particular subset of those sex and gender-based stereotypes and harms, namely how Mississippi's law targeted women and particularly women of color and poor women of color based on those stereotypes. And then throughout the brief, when we were referring to the law's impact, we tried to be careful to emphasize who was primarily affected, in this case, low-income communities of color, as we've been talking about, which of course include people of all gender identities. So we tried to be clear that that was the case throughout and refer, when we were making more general statements about impact, in a more sort of gender inclusive way to pregnant people and to individuals who have rights under the Constitution. So I'll stop there. Really look forward to others' thoughts on this, both with respect to abortion specifically, but also more generally, questions of reproductive rights and justice and how to make them more.
Riva, do you want to supplement those thoughts?
Yeah, I mean, I will say that we had something of a seminar among ourselves as we were working on the brief, as we were trying to coordinate these various goals about what gender inclusivity meant and about how to effectuate it in the particular circumstances of writing this brief to this audience. Because among other things, when you're writing a brief to a Supreme Court brief under particular word limitations and with a certain audience, you can't really incorporate like comment bubbles, having a reflection on sort of what certain sentences mean or are doing or whatever. So, but we did actually quite self-consciously try to draw a distinction between the articulation of constitutional rights as available to a certain community inclusive of persons, for example, of all genders or gender identities on the one hand, and on the other, trying to do something that actually was quite new, which was to try to take an available account of sex stereotyping, one, extend it to sex stereotyping of pregnant persons, but here, pregnant women, you want to call it cisgender women, and connect it to the abortion context and make a bridge between that and the existing doctrine that would be in short form intelligible to a set of readers, not just the court, but the world at large, to show that utterances in the existing court's cases connected to this material, some of which would be recognizable, but others of which was not. Like, for example, because I tried to make my comments quite brief, I didn't have time, for example, to show you what's in part 2 of the brief. There is in the preamble of the Mississippi statute, not only the fragments of protectionist, gender paternalist claiming, but also certain claims about abortion's harm to women. So they look like empirical claims about the kinds of injuries that women might suffer in abortion. And they're described as health harms to women. And what we do is to show that these are based on empirical mistakes that aren't just mistakes. They map onto a certain kind of stereotype about what happens if women resist the maternal role that can be traced back to claims that the 19th century doctors made when they were arguing for the urgency of stopping women from resisting motherhood in the course of the campaign to criminalize abortion in the 19th century. So what's the relevance of that to the conversation you've put on the table? We were trying to show people that would look like utterances about physiology or physical harm were in fact part of a set of moral hazards claims that have a history in stereotype, a discursive history, really, that needs to be recognized, that aren't intelligible to ordinary readers. And we needed to be able to show that there's a gender stereotyping history. Now that's my point 1. Backing out to the goal of gender inclusivity, my suspicion, and I maybe will turn to ask Carrie's views about this or your views about this, my suspicion is that a goal of gender inclusivity might take the form of recognizing that there are many forms of gender stereotyping, and that what we need to do, that if we understand the problem intersectionally, we need to recognize that there are different kinds of gender stereotyping directed at different kinds of women. So for example, in oral argument, when Justice Barrett started talking about safe havens, she's assuming that the thing to do with a pregnant woman is just give up the baby. And, you know, that's assuming something about the nature of their motherhood, you know, which is, it's undeserving motherhood. It's poor women who don't deserve to be enabled in their motherhood. But, you know, I mean, there's a whole backstory there that I think is connected to what Carrie was talking about class. But we, you know, the newspaper coverage of that didn't fill in what I think it deserved, which is, that's not just gender, it's neoliberalism. What on earth makes you think the thing that someone deserves is dropping off the baby at a fire station? Excuse me. There's a bigger set of assumptions back there about what it means to provide for, I'm pausing because I'm looking for an appropriate way to put this, to mediate the conditions of possible expectancy there. So I'm just saying that we could ask a set of questions about what inclusivity entails and what we need to do in talking about this topic to become inclusive. And one of which is recognizing this set of stereotypes, but of course we need to recognize other forms of stereotypes that afflict people who are trying to access healthcare also.
Thank you. Carrie, do you want to jump in at all?
I guess I'll just say, you know, I think some of the way this argument has played out is frustrating. And I'm going to be a little bit caricaturish here, but there has been one set of reactions, which is to be quite hostile and resistant to the inclusion of pregnant men and transgender men. out of a fear, I think, that this is distracting from the centrality of women, the history of women's oppression, that it potentially renders the sex equality argument incoherent because now you have women and men both claiming pregnancy, and I think there's been sometimes a hostility to that form of inclusion. On the other end of the spectrum, and it's a reaction I see sometimes among my absolutely beloved students, is a desire to scrap the sex discrimination argument on the ground that it is inherently exclusionary, and we should go with some kind of sex neutral pregnant persons in all cases as the rule. Let's de-sex pregnancy, let's make it about liberty and autonomy of bodies, and leave behind what seem like second wave feminist arguments. I just don't find either of those extremes particularly appealing, and they seem unnecessary, and I think there's a better route forward. So I will just say, not that I have all the answers, but I have a few thoughts about this. There is work being done in the medical field that I think could be a useful model for lawyers in thinking through this question. There's a physician at University of Michigan named Daphne Struisma who has written, I think, quite intelligently about this. And what she says is sometimes a sex-blind, sex-neutral approach to pregnant persons will work and make sense. Everybody needs vitamins. Everybody needs blood pressure screening. Everybody needs a certain standard of care, and all pregnant people need that. But there are different needs as well. And we need to be attentive to transgender men and ask, what is a course of hormone treatment? How does it interact with pregnancy? What other needs and screenings and attentiveness to gender difference will be health and will be care in some circumstances? And I'll just advert for a minute to, she wrote up a case study of a situation where a transgender man came to a hospital. He was obese and he had stopped taking his hypertension medication. He had high blood pressure and he had stopped taking his medication. A nurse triaged him and determined that he was stable and put him in the waiting bay. So it was hours before he saw a doctor. When the doctor arrived, the doctor determined that he was pregnant. There had been a cord prolapse and there was a tragic ending, and the fetus died. And in this case, that fetus may probably, this physician concludes, would not have died if this was a woman, because they would have instantly tested for pregnancy. And that would have been one of the, if someone were presented with lower abdominal pain, that would have been one of the things they looked at. And what she writes about in this article is the way that stereotyped conceptions about men will not be pregnant led to a death. And is creating serious health risks around the country in all sorts of ways. Our care is insufficient for these men. And I think we need to have room to say there are stereotypes that women will or should be pregnant. There are stereotypes that men can't and won't, that are hurting everybody. And this is not antithetical or in any way a threat to, I think, the best feminist understanding of sex equality. We have had a doctrine that talks about no one being allowed to be subjected to the stereotypes associated with their sex. I mean, Ruth Bader Ginsburg brought cases with male plaintiffs in the first place 50 years ago to show that everybody is harmed by this system. So my hope is that there's a way of talking about sex role enforcement that doesn't erase all the history that Riva and Serena and I have been discussing today, and that can talk about stereotypes associated with cisgender women, but that can also talk about stereotypes associated with transgender men. They may be different, but they're part of a whole system that oppresses us all. And that seems to me the way forward, right? These claims are amplify and enhance one another. They're not inherently in conflict.
That was deep. Can I just say one thing that maybe is an additional point here, that is like building on what Carrie just so lucidly and passionately just put down there. And it comes from a dialogue she and I have had. In the race context, you would never say to somebody, okay, the way to be inclusive is do race blindness. And, it's just color blindness, And part of what the difficulty of proceeding in that way in the race context is you couldn't unpack or make intelligible the way that race is still operative in so many contexts. And I guess that's sort of true in this brief. We're trying to make intelligible the way that gender is placed in places that people don't see it operative. But that doesn't mean that there isn't deep and powerful cautionary that is produced by this collision here, and that one can't learn from this dialogue. And so the way that Carrie is pointing is basically to say, look to see, I think it's an intersectionality point. It's to see how many different forms of stereotyping are there, and then to figure out what are the contexts in which it's appropriate to proceed, in which you can achieve inclusive. Here's the way I think I would put it. How can you achieve inclusivity by using blindness? And when will blindness prevent you from seeing the forms of exclusion and subordination that are continuing to organize things? And what are the tools you have to try to get at them?
Great. This was really helpful. And the takeaway I get from Carrie, but all three of you, is to understand and really in a way update Ruth Bader Ginsburg's stereotyping argument in the pregnancy context, such that we understand the sex stereotyping that attaches to pregnancy historically and legally impacts not only pregnant cis women, but all people. And it is a gendered harm, experienced differently, perhaps given your gender identity, but it derives back from particularly stereotyped ideas about pregnancy and women. And that is, I just think, a really well crystallized way to think this issue. And I think, part of what is so frustrating, if we look at what the court did in the Bostock case, is refuse to see stereotyping as an animating norm, at least under federal statutory sex discrimination protections that might extend to equal protection, we don't know, and revert back to this sterile, I guess I mean that both metaphorically and not, way of thinking men and women. And so given that the court is not really ready to embrace the stereotyping argument that advocates and some prior members of the court have advanced, and also recognizing Carrie's point that these briefs are not, the audience for these briefs are not only the Supreme Court, how do we argue about the ERA? Just to bring us back to one of our foci for today, how do we argue about the ERA in its relationship to the existing Supreme Court jurisprudence? Why do we need it? Will it pull imminent threads out of the jurisprudence and lift them up, maybe the stereotyping and other arguments, make the Equal Protection Clause a better form of protecting against sex-based equality, including stereotyping? Or will it repair the injury of what our current equal protection doctrine is? In which case, I think, I hear all three of you saying, no, we have what we need with the Equal Protection Clause now. We just need to push the court to see it differently, or more broadly, or conceptually in a way that is more attendant to stereotyping. So how do we square what the arguments are that you're making, that we have what we need already in the Equal Protection Clause, we just need to convince 4 or 5 members of the court to go for it, with the idea that we also need the ERA when it comes to abortion rights?
Well, for one thing, I'm not going to hold my breath with 5 members of this court. So I'm more of the view that Carrie was adverting to earlier. And when Serena can report the fact, Serena, isn't it the case when we wrote this brief, we were writing it for dissenters on the court, but really we were writing it for people who might read it, readers of the court, readers of the briefs, not just the court, because our view is that given the present membership of the bench, however they got there, bracket, that the law will evolve in other fora, both legislative and state judicial, and for that matter, on the ground, et cetera, in all arenas, And as it does, these kinds of arguments are going to take different forms when they're asserted by people in politics, people in legislative arenas, people in different settings, to be sure. But I do think that, first getting them out and attaching them to Virginia and attaching them to fundamental existing case law is really crucial, because it shouldn't be that. I think that we can make a claim that it's in our tradition. And here I'm going to say something. At the beginning, I said that there was history I was leaving out. Back in the early 70s, and this is something that all the panel could weigh in on, back in the early 70s, movements were making these arguments about Title VII, about ERA, and about equal protection all together, all at once. And the court just broke away, and there was a grand battle, and the only thing that survived was the Pregnancy Discrimination Amendment. But the arguments were out there, and they found a toehold in the PDA, and they grew from there. So what does that say about the ERA? I mean, Ginsburg and others made the argument that strict scrutiny applied to pregnancy discrimination under the ERA, but she also made it under the Equal Protection Clause. So the ERA was incredibly generative for the Equal Protection Clause's growth. And so there's a dialectical relationship that goes back and forth. So, I mean, I'll leave it to the other panelists, but I think that these arguments can be pressed in different forms and will be pressed, but people shouldn't be afraid to. What's been really hard is when people, as too often happens, say that the ERA doesn't protect reproductive justice or doesn't protect, trans rights or whatever. Then you get a claim for equality that's narrowing existing case law. And we're speaking against that,
Yeah. By the way, I've just uploaded both your Dobbs brief and our Pennsylvania brief into the chat. They're in the CLE materials and the materials for the conference, but they're more readily available right in the chat now. Serena and Carrie, you want to add anything to that?
I think I would just underscore what Riva said and just, emphasize the point that these are, throughout the ERA's history, as Riva mentioned and has written about, these arguments are being made simultaneously in all these different venues. And I think that a key point to think about in arguing for the ERA is just to be careful about saying too much about the limitations of the Equal Protection Clause in a way that casts doubt on whether the Equal Protection Clause could be interpreted to have these more expansive meanings. And I think that's a very possible thing to do and something that people, have been and are doing.
So what I'm hearing is that an ERA doesn't need to necessarily indicate a 28th Amendment, a break with the 14th Amendment, but in a way have a kind of relationship to the 14th Amendment that would lift up the rights that are there in a more expansive way than we have them now. Is that a fair way to illuminate the relationship of a 28th Amendment to the 14th?
Yeah, I mean, I guess I want to, the three of us are of one mind on the 14th Amendment question. I think it's very clear to progressives, to progressives in the context of race, that the interpretation that the court has made of the 14th Amendment is an incorrect limited, narrow, conservative understanding of the 14th Amendment. We're going to get an affirmative action case next year, and people will argue it is wrong and that the 14th Amendment doesn't stand for this thin, anti-classificationist, regressive understanding of equality. And that's just true in sex as well. The current Supreme Court, the court started interpreting the Equal Protection Clause in the context of sex around the same time that it shifted in a conservative direction in the 1970s. It is not a surprise that we have gotten limited, conservative, thin, regressive, not wholly. I mean, I think we've talked about some of the ways that the 14th Amendment is protective, but it is not anything that any of us would want it to be. And I don't agree that that's an inherent limitation of the Constitution we have, but rather of the readings that have been placed on that amendment. So I just think it's a mistake. We will not always be we. There will be new people. There will be new generations. There will be new courts. And the 14th Amendment will have a new life, is one of my fondest hopes. And I don't think it behooves us to now say, to build up the case that the conservatives are right about their current readings of the 14th Amendment. That said, I think advocacy around an ERA can have an important democratic, galvanizing, organizing effect, that all of these claims are still alive, that they were part of ERA advocacy, that we should uncover that history, that we should explain all of the rich concerns that drove it, that produced state ERAs, that still drive the movement, that can be broader in understanding than what those 5, now 6 people on the court think sex equality means. So absolutely, I'll just say, supplementary, complementary, enhancing, expanding, but not replacing or contradicting.
Great. All right, so then let me ask the next hard question, which is strict scrutiny. Reva, you had said that Ruth Bader Ginsburg had endorsed the idea that the Equal Rights Amendment would create a high level of scrutiny for sex-based inequality on the level of strict scrutiny. She also thought the Equal Protection Clause did. I think she said that before strict scrutiny started doing nothing. And so it was a different version of strict scrutiny than the we have now.
Correct.
In terms of thinking about what an ERA might do, many advocates make the claim that the best thing about it is that it will expose sex discrimination claims to strict scrutiny, just like race discrimination claims. And we spent a good part of a panel yesterday talking about that might be not the right messaging around the ERA. Where do you all land about the issue of strict scrutiny? Is it somewhat similar to where Carrie was, which is we got to fight for it to do more work too, for everybody, including sex discrimination, or should we rethink the equality paradigm? Serena, you look like you were about to start, so I'll call on you.
Okay, terrific. So I think, I think it's very dangerous, as we were talking about yesterday, to talk about strict scrutiny as the end goal of what an Equal Rights Amendment would accomplish, or about what we want to accomplish under the Equal Protection Clause, because as you said, strict scrutiny means something completely different than it did when Ruth Bader Ginsburg initially argued for it in the early 1970s. That was, before strict scrutiny meant fatal, in fact, to affirmative action and all kinds of programs that might be geared toward remediating inequality. I think that there are tools, and I think we talked a little bit about this yesterday too. There are tools, nevertheless, within equal protection jurisprudence that have perhaps lain dormant, including some of the sex equality analysis that is contained in U.S. versus Virginia. So there's some really strong anti-subordination language around the discussion of exceedingly persuasive justification and intermediate scrutiny, saying sex-based classifications can be used to ameliorate discrimination and inequality with respect to women. And so, and I think, I think Reva and Carrie and I have all written about how Ginsburg used those to argue back that race-based classifications should be able to be used for similar remedial purposes.
Can I just read that? Do you have that language available? Can I read that language, Serena, and then you can continue? She
Of
says
course.
in Virginia, sex classifications can be used to promote equal employment and opportunity to advance the full development of the talent and capacities of our nation's people. But such classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. So, I mean, that's the passage that, I'm sorry, go ahead, Serena. So she's
No,
doing
that's exactly
language, you know?
Yeah, no, I think that's exactly the point to focus on.
Great.
And I'll just add, you know, what's interesting, I see so commonly advocacy around the ERA arguing for strict scrutiny and claiming that the ERA will bring strict scrutiny. It's very clear to me that the people making that argument are not asking and do not mean strict scrutiny as it is defined in the legal world today by this court. So we have a bit of a language mismatch. That's an unfortunate one because strict scrutiny has taken on a meaning it doesn't inherently have and hasn't had at other points in history, but currently and for some time now has meant a kind of commitment to blindness and lack of context and lack of historical awareness and lack of concern about who's being hurt and who is being helped and what the legislation we're talking about, what the state action is doing. And that is really not what any ERA advocate I know is asking for to be applied in the sex context, right? So, you know, women, Title IX is now a concern because it divides, you know, or affirmative action or women in STEM, all of that is really what we're targeting when we advocate for the ERA. But when you say strict scrutiny, that's what it's good at getting rid of today. It's good at getting rid of programs that try to help in a lot of cases. But what I don't actually think there's a deep conflict because advocates aren't really arguing for that. They're arguing, I think, we need a new term, better scrutiny, smarter scrutiny, anti-subordination, anti-stereotyping. I think we're actually all in agreement about that. What we need is something better than what the court has done under the 14th Amendment. Strict scrutiny is an unfortunate name to give that thing that we all want.
Great.
I think I can add something as I'm thinking about it. I doubt that they want anti-classification. They probably want disparate impact or something, which in fact, if you go back into the legislative history of the 70s, ERA is back there because the ERA came out of Congress before Washington against Davis when race discrimination law was understood to comprehend various forms of disparate impact. It's Davis that starts to obliterate that. So it's an interesting question Carrie's putting on the table, what strict scrutiny is meaning to the people who are asking for it.
Yeah.
But going back to what I was about to say and pulling together some strands of conversation yesterday, I think that part of what's being urged in it and responding to Catherine's question, I think part of what's at stake in an ERA is, or in the mobilization for an ERA, whether or not it becomes recognized by persons in authority as law. Part of what's so urgently at stake is focusing, one, on paradigms of gendered significance, paradigmatic scenes of gendered significance, so many of which are at stake in the conversations in the most recent ratification campaigns, whether it's talking about Title IX or it's conversations about pregnancy discrimination or about violence or you name it. So certain foci of or paradigms of locations where questions of equality are of heightened gendered significance. And two, and this is something that I've long been in conversation with Julie Sook about raising up whose stories count as constitution makers, who counts as the makers and framers of our Constitution. So whose voice, who counts as authority, that also matters tremendously. And that's also in motion with, I think, a mobilization for an ERA.
Well, I think that I agree with all of you. And I think Carrie's point about what the advocates are asking for is that sex discrimination be given serious treatment, more serious treatment under the Constitution than it currently is absolutely what underwrites that demand for strict scrutiny. But I do think there is a lack of education among a lot of folks in this country about what the Constitution does and how the court has narrowed it so considerably. And that at times people are asking for strict scrutiny, thinking that what they're also including in that is disparate impact, is discrimination that's not on its face intentional in nature. And so that, that's our job as, I think, educators, is to not only teach our students within the four walls of a law school about constitutional standards, but everybody. So that we're asking for the right things in the right terms. Now, if I can pivot for a second to another large concept, citizenship. One of the things that distinguished Ruth Bader Ginsburg's approach to sex equality is the degree to which she linked it to women's full citizenship. In many of her writings and judicial opinions, she often voiced the view that reproductive rights, whether it's access to contraception or abortion, were instrumental to women's full citizenship, that one couldn't function in the wage labor market equally. One couldn't function in public life equally if you can't control your reproductive body, if you didn't have that kind of agency and freedom to control your body, which is very different from saying that reproductive rights are valuable in and of themselves, which I think she also believed. But also in her opinion, she linked sex equality to the 19th Amendment and women's right to vote. And there are moments when I wish the Equal Rights Amendment was actually titled the Equal Citizenship Amendment, so that we could think of it as a bit more broadly. But I want to invite the three of you to think about the relationship of equality to citizenship, the relationship of the 14th Amendment's conception of equality to citizenship, and then what an ERA might do in deepening or expanding that conception. Carrie, I'm going to call on you because I've called on the others.
Riva literally wrote the book on this.
I know,
I'm going to defer to her.
I knew she did, but I wanted to see if you wanted to supplement anything you can anticipate she might say. Okay.
I would like Riva to take this one first.
I know that Riva wrote the book, but giving you two space. All right, Riva.
Wait, Serena, did you want to?
Give us the elevator speech on the relationship between sex equality and citizenship. Because not everybody listening, I think, connects those dots in the incredibly important way that you do.
Well, I think Carrie's pointing to some work I did around the 19th Amendment, in which I pointed out that the entire argument for denying the vote was based on the idea that women took their citizenship through family relations, either as daughters or as wives. That's the political imaginary, through virtual representation through men. And so that enfranchising women was disrupting family relations and was fought that way, most importantly, fought that way for hundreds of years. And so that by treating the 19th Amendment as a rule about voting that's been essentially satisfied, non-discrimination rule about voting that's been satisfied, we completely miss the extent to which the debate over voting and the federal government's intervention into the question of enfranchisement was from start to finish a debate that ran from the antebellum period all the way through, in fact, really to the present, an argument about family structure, family relations. And that once we see that and see the structure of gender status inequality as a structure of dependent or derivative citizenship, we are in a much better place to grapple with a long history of debates over liberty and equality, which actually has been, as I've written most recently, erased from our constitutional record. If we recovered it, we'd see that these debates actually take place in fights that are part and parcel of the 13th Amendment, 14th Amendment, 15th Amendment, 19th Amendment, all over the place. They're parts of our constitutional history, and they feature arguments that we would treat as arguments having to do with reproductive justice. In the vernacular of freedom and liberty, persons arguing that if they don't have control over ability to speak about and for these matters, they don't have liberty and freedom in the constitutional republic. And they use stories having to do with constitutionalism and otherwise to try to assert this, whether in pursuit of freedom from slavery or the vote or otherwise. So that's the short form of it. And I wrote about it some in a piece called The 19th Amendment and the Democratization of the Family, and another more recent piece flying under the title of the Politics of Constitutional Memory. But in any event, the whole point is, while we think about race as having a constitutional history, we don't really think about gender as having one, but it does. And when we come back and look at those fights, we can see those bridges are tied around family to a remarkable degree, and they're actually constitutional fights to a remarkable degree. And these are part of them. And the ERA gets caught up in them, as does the constitutional history of all those amendments.
Yeah, thank you. We had a question from some folks in the audience about the relationship to citizenship, so I wanted to draw that out. Serena, do you want to add something to that? Because your work has also engaged these issues of citizenship as well.
I don't have a lot to add to what Riva said, but I did just want to mention, I mean, maybe this is too obvious to say, but you know, at the bottom of all of the rights that we're talking about, you know, is the fact that people need to actually be able to exercise their right to vote in order for us to have all of the things that we're asking for here. So an ERA and any other legal or constitutional provision isn't worth very much if people aren't able to participate as democratic citizens in the polity. And so I guess I keep sort of just returning to the idea that voting rights and other responses to attacks on democracy are, you know, needless to say, very foundational to the actual process of preserving and extending the rights that we already have.
Yeah, I had a conversation with Marianne Glendon the day after the Dobbs argument, and I think the last words out of my mouth are voting rights or reproductive rights.
Great. So Serena, you dropped a little bomb that went by kind of quickly, and I want to return to it because I think it's worth spending just a little bit of time on, which was to say that if and when the Supreme Court overrules Roe, we'll actually be liberated from having to defend and have a kind of fidelity to a rule that almost nobody who was an advocate of either sex equality or reproductive rights or justice ever would have wanted in the first place. And it would free us up to think differently, advocate differently, work differently. Say more about that, because not everyone's going to sign up for that view of what the consequences of Roe are, or Roe's overruling might be.
I would love to take credit for that point, but I think it was Carrie who made it, so I'll let her answer.
Yeah, I said that. So
I thought it was you. I'm sorry.
No, I appreciate it. I completely agree with it.
Okay, Carrie, go ahead.
Yeah, I guess I will take ownership of it. I guess I will just say this. It is my sense that the articulation of abortion rights doctrine that we got in 1973 on a court composed of 8 white men and 1 Black man, more than about half a century ago, is not the fullest and best articulation of reproductive rights doctrine that we could have hoped for. Obviously, that is the case. Roe did not articulate that. Roe left a lot out in the articulation of the right. And one of the things that it left out, and I think part of the reason for this whole panel is it really left out a lot of the discussion we've been having for 90 minutes. If you read Roe, this is not how it sounds. Roe talks in a register of a privacy and a woman and her doctor making decisions, at least through some point of pregnancy, without the state coming in and stopping them. That is a very partial and incomplete understanding of what's at stake here. I think our conversation has shown there is a universe of justice and equality that is not captured in Roe. Now, Roe protected an incredibly important right that is central to people's equal standing and in some cases survival and citizenship and flourishing. And advocates have been working in the trenches for many decades to protect and preserve what we got, which is perhaps not what we would have asked for, but was something and was worth saving and worth arguing for. And the arguments tended to, understandably, I think to some extent, repeat back what the court was telling us and say, you told us this, you told us this, we're going to argue in this vein, we're going to defend it, we're going to stand up for it. And there was not, I think the sex equality argument was not foregrounded because it didn't seem like that was what the court was attached to, and that was not the ground on which this right had been won. And so there has been an attachment to defending a kind of privacy, liberty, bodily autonomy rationale. That's an important part of the story, obviously, and that is not going away. What I meant to say was that, okay, that will, when that goes away, actually, because the court takes it away, I think that gives space now to think about a fuller understanding of what these rights are. We're 50 years on. We've talked in the ways that we've talked. We understand the history better. We understand the claims and what's at stake in a more complete way. And it just means that I think the three of us are suggesting, and Catherine's brief suggests, that the equality claims can now be a bigger part of the story than they perhaps were when defending Roe to the death was the central point and focus.
Great, thank you. And to what degree might the ERA be a spark plug? Should it, I mean, I see a path for us to finalize the ERA in the near term. Although it looks kind of bleak in the Senate, I think there are ways for us to get over the finish line. And I think David Posen's kind of closing for the panel, the first panel yesterday, left us with that optimism as compared with a lot of other things that I think are a lot harder to do right now. So again, to invite you to relate some of your comments to the ERA, how do you situate the ERA in that new political landscape? And this will be to draw out a question we've gotten from one of our people in the audience, with the sensitivity to the fact that it comes at some cost, because there are people who might otherwise support the ERA if they didn't think it was linked to abortion rights. That has been sort of the cudgel that's been used by the right to that and trans rights to defeat further ratifications of the ERA. But I think that's a price advocates are willing to pay and are willing to engage. So how do we understand that new landscape, that new ecology of equality in a world where we have an ERA or are close to having an ERA and we don't have Roe versus Wade anymore?
Well, isn't there going to be a dynamic? There is a dynamic, I'm sure, where some people say, look, we want to get an ERA through, so we should say it won't change anything to do it. if we promise that it's going to change things, then it won't get through. And so the ERA, the drive to pass the ERA will become the drive to, becomes the vehicle for asserting that equality has nothing to do with, and then you name the list. And so in a certain way, that's what these panels about, and so all the alternative is you say to say that the ERA is going to do all these transformative things, and the fight then becomes a movement that's just succeeded in overturning Roe, turns around and tries to block an ERA. So I'm sending that back to you.
Carrie and Serena, do you want to share any thoughts on political strategies, framings? I see wheels turning.
I mean, doing this about the Equal Protection Clause seems an all considered, I mean, making these arguments about the Equal Protection Clause seems like an all-purpose good. It seems to make it easier for ERA advocates to say, look, this argument is already out there about the Equal Protection Clause,
Mm-hmm, mm-hmm.
Anyway, I'll let others speak.
I guess I'll just say, this move was made by some feminists in the 1970s to say ERA, equal protect, whatever sex equality protections we have, to kind of disavow that they would reach sexual orientation, to disavow that they would reach abortion. We have tried that and it got us absolutely nothing.
Nowhere.
It didn't make law more robust. It didn't make protections more robust. I think there is a very clear lesson from the 1970s and the histories we lived through that trimming our sails, that excluding major constituencies and very important rights. In fact, I guess if we're going to exclude reproductive rights and sexual orientation and gender identity, I'm not even entirely sure what we're fighting for. Anyway, we've done it, and we are still arguing for more because it didn't get us the robust protection. So I guess I just think it's not as if we can jettison LGBT people and people who need protections in the reproductive sphere and then get a plethora of other valuable things, and that's a worthwhile trade-off. It's no trade-off at all, and to me it's not worth fighting for if those things aren't going to be included in central.
Great. Serena?
I don't have too much to add to that. I would just say, again, I think making the most expansive equality arguments we can in all of the venues that we can is the way to go. And, there may be a political downside to doing that, but as Carrie said, I think there's no upside to not doing it. And so, so it's an imperative.
So I'm always a fan of trying to learn from my enemies or from my opponents. And we're at a point in where the court is going in terms of respecting rights, of applying an undue burden standard in the repro context, where the people who are asserting reproductive rights are asked to bear incredibly weighty burdens before the Constitution is even implicated. On the other hand, the court is applying a substantial burden test in the area of religious liberty, that any law or policy that imposes a substantial burden on religious exercise or belief has got to come up with a very good justification. State does very good and powerful justification to impose that burden. And in those contexts, faith-based objectors to complying with laws that apply to all the rest of us are seen as almost fragile. Like any burden is too much. So no burden is enough in the repro context, and any burden is sufficient in the religious liberty context. Besides packing the court with the three of you, which is sort of what the religious right has done with their people, how can we learn from the strategies, the forms of arguments, the movement building, really, that the religious right has mobilized so effectively, of not just getting their people on the court, but actually presenting a set of arguments that have really radically transformed religious liberty law at the very same time that racial discrimination, sex equality, those sorts of things seem to be invisible to the court.
I want to, Carrie, Serena, do you want to come in?
Go ahead, Riva.
Well, I do want to draw attention to the fact, without in any way, I mean, I'll try to sort of think out loud with you regarding your question, but I do want to draw attention to to the fact that there has been some procedural irregularities or more with respect to the composition of the court, and that it is at odds, or it is going in directions at odds with the views of the American public. So part of where we're at is by mobilization on the right, is achieved through mobilization on the right, and part of what where we're at is through processes colleagues of yours might call asymmetric hardball, and others, you see Carrie smiling, but so in other words, if certain confirmation processes had gone differently, I don't know that we'd be exactly at the juncture we're at right now. However, going back to—
1 second, Riva, just asymmetric hardball is that the other one side's willing to do almost anything to get what they want.
And the other side, yes.
The other side is willing to play by the rules, cares about the institutions, and et cetera.
So that's partly how we find ourselves at this pass. All of that said, I do think that there are certain things that I can observe about the way that the right is proceeded. They assume that they're trying to make they base their legal arguments in part on cultivation of the claims as a matter of culture and not just legal argument. They're assuming that they have to be tied together, that you can't just make arguments in court. And they move concurrently between claims in politics and claims in courts. And one of the things that I think is important about the equality reframe of these claims is that it facilitates a much broader based coalition of claimants and actors around a much broader based set of issues than does the privacy liberty argument, across a much broader based set of arenas, so that you can sort of draw the connection. The equality argument tells you what the connection is across a set of issues, why the abortion right is connected to many other sets of questions in politics and many other sets of claimants. It provides you a language for drawing the connections, making them much more visible as a matter of mobilization and as a matter of law. And I think that that would be helpful on a number of points. It also helps speak about intersectional questions and helps in a coalition politics way, than does some of the language in which the court's case law is presently situated. And since, as Carrie was pointing out, this right is going to have to move into vindication in other settings as a matter of reproductive justice in legislative settings and in administrative law settings, and not just in judicial fora, I think that it's helpful to speak in this equality language. It can more naturally be justified and explained to people than some of the other language. I don't think you have to get rid of the liberty. I heard some people speaking in favor of it, but I actually think that and Carrie would be the expert on this, the sexual stereotyping argument is in the end, an argument for getting government out of making decisions about how you want to fashion. You're about providing to individuals, to persons, taking from the state control of decisions about the way you perform your gender.
Mhm.
So there is a liberty equality nexus at the core of the anti-stereotyping principle.
Well, and I will, just note that almost all of the cases where lesbian and gay couples or individuals have won in the Supreme Court, thanks to Justice Kennedy, were liberty equality cases.
Absolutely.
These
Absolutely.
were kind of inextricably woven rights. And if you try to teach these opinions, it's very difficult to kind of pull them apart, and perhaps not actually even necessary to do so. But so there's a strong jurisprudence already of equality that draws from liberty, but it hasn't seemed to export into the sex equality context. LGBT people have been more the beneficiary of that weaving of liberty and equality than I think, just straight up, if I can say, sex equality cases have been.
One of the things I think is important about what I sometimes call expanding the frame, so that you don't have this single issue focus on abortion, but you're thinking in reproductive justice like ways, looking at the larger ecology about what it takes for persons to have flourishing families of every kind. One of the things that happens when you look at the policies that are at stake that enable persons to have those, to be supported in making those decisions and to have healthy family lives. When you do that, you can begin to say, okay, what's the possibility of conducting this set of arguments in a blue state, in a purple state, in a red state? And it's going to end up looking like a different set of arguments in different political ecologies, And I think we need to be able to think that way, because we're going to be having those arguments in a completely, localized sort of way. And so one needs to be able to be agile about it and flexible and think about the new forms in which this is going to happen. Some of these coalitions are going to look purple, and they're not going to be about abortion at all, and so be it. That's fine. If one wants to talk about maternal mortality and one wants to talk about healthcare, and that's great. Have that conversation, because those are implicated in profound ways in the Mississippi case. So I think that it's really, and you don't see that when you just have this kind of abortion-centric picture of this. It's implicated in the Mississippi facts, and in the Louisiana facts at issue in June Medical, and in the Texas facts at issue in Whole Women's Health. All of the legislative histories for every one of those cases, the opponents of the restrictions would say, you cannot push people into motherhood in these states this way, they would say to the pro-life community, given your policy choices, rethink, just as Carrie was saying. So it's a huge set of choices, and there's a way to get new coalitions around all of this.
Yeah, and Catherine, just to pick up on your notion that there's something to be learned, having just spent the past decade in Texas, I will say that I think the right has been quite successful in tapping into deeply resonant and emotional forms of language and strands of American culture and history around family liberty and family autonomy and freedom, and all the while setting neighbor upon neighbor and engaging in vigilante justice, in which the state is coming in and is going to start interrogating everyone who has a miscarriage, snooping in everybody's lives, now prosecuting parents who receive healthcare for their children. I was listening to the response by Senator Reynolds in the State of the Union, and she was talking about this is the pro-family, pro-parent revolution. And I just think, as Riva was saying, in red and purple areas, that language doesn't belong, I think, only to the right. There is an enormous well of kind of tropes and sources of meaning in people's lives around family autonomy and family equality, and that it seems to, from my perspective, states are wildly violating. And the fact that the religious right that you're talking about, it has claimed ownership of some of those constitutional and cultural values, strikes me as something that should be pushed back against, because as Riva says, I don't think that actually is where the majority of American people are. I don't think the majority of American people support some of this Texas legislation. And I think there's ways of talking across political difference about how this isn't what freedom looks like.
Right. Well, and to lift up a thread that's run through all three of your comments, but we haven't had the time to spend more time on, a reproductive justice as opposed to a reproductive rights frame would give us many of the tools to make that appeal, where the idea of what's at stake doesn't end at the delivery of a baby or the end of a pregnancy through an abortion, but continues through a person's life. We have Loretta Ross and other feminists of color to thank for providing us with a reproductive justice frame that understands maternal health, postpartum health, the interests of any of us to see our child grow up to a full adulthood without being shot by police, all sorts of violence that happens, particularly to people of color in this country, are reproductive justice issues. And so expanding that frame beyond merely terminating a pregnancy, which is, I don't want to say it's a small thing, it's an enormous thing, but beyond termination of pregnancy, or Justice Barrett's idea of surrendering a child to a firehouse that ends the consideration of the Constitution, or our work around reproductive justice, I think is enormously helpful.
I mean, that is the point, Catherine, of all of the whole second half of the brief is just to expand the frame and to say, how can Mississippi be claiming that this is love? Just look 1 inch beyond the abortion context at the choices this state is making. It has the highest infant mortality rate in the nation. Look at what it's doing in terms of providing health care and assistance to these families. Then one needs to ask exactly what is it doing when it's reaching out to control in this way? Exactly how does it care about the people whose lives it's controlling? How does it value life? And that's what the brief is trying to make the reader ask. And we don't have good legal languages to make visible the intersectional forms of animus behind that, but we're trying to show it at every twist and turn of the whole brief.
Great. Well, you have the brief, the Dobbs brief that Serena and Riva and Melissa Murray authored. I commend you to all of Carrie's work, so incredible, which she's continuing now at the Williams Institute at UCLA and on their faculty and her own work independent of the Williams Institute. You've got the brief that we wrote in the Pennsylvania case. We're waiting on a decision there. Fingers crossed that the Pennsylvania Supreme Court will see abortion rights as a component of sex equality. And I also want to direct you to the ERA Project's website, where a lot of what we do, there were some questions in the chat or the Q&A about, please break down what strict scrutiny is. What does that mean for people who are not lawyers? That's a lot of what we do at the ERA Project, is make accessible these really they're pretty complicated legal questions for folks who are not lawyers or trained in law. When a new decision comes down, we'll issue an explainer of what just happened. Why does it matter? Why do we need the ERA? What will it do? And so I commend you to go to the website and the work that Ting Chang, as our director, is doing there. If you're interested in the religious liberty stuff, we also have a Law, Rights, and Religion project here at Columbia, and Elizabeth Platt directs that project, and we also try to break down these complicated religious liberty questions there as well. I hope all of you will join me in thanking Carrie, Serena, and Riva for what has just been an amazing conversation about what it is to be free, what it is to be equal, what it is to live a life with dignity, really, as mobilized either through the Equal Protection Clause or the ERA. This has been incredibly helpful. I know the folks that have been watching have also found it incredibly helpful. We will continue the conversation, but we have to end it for now. So thank you so much, the three of you, for the work you do, the hard thinking you're doing, and the leadership that you've really given all of us in how to move to the next stages of these struggles.